Yet not even the New York Times thought that news, the news of Swift's demise, immediately fit to print. Justice Stone, 1 week after Erie's release, wrote privately to Arthur Kroc of the New York Times, calling Erie the most important opinion since I've been on the court. The message took hold, and the next day, Kroc devoted his column to the momentous decision. He began with this auspicious comment: "If the Supreme Court, like so many other arms of the government, had a publicity agent, 8 days would not have passed before the importance of its decision in the Tompkins case became known." Though Justice Brandeis delivered this transcendently significant opinion a week ago yesterday, it has generally eluded public notice. You can contrast that with the many reports in the press this week following the Chief Justice's announcement of his decision in the gun possession within 1,000 feet of a school case. Since 1973, our court has had, if not a publicity agent, a full-time press information officer, today aided by a staff of 4. Before that, the court had a press clerk first installed in 1935. The mission of the Public Information Office is to furnish reporters with the documents they need to write their stories. One of the most experienced members of the Supreme Court's press corps has called the office indispensable as a supplier of documentary information and answers to process questions. Tony House, who currently heads the office, has differentiated its work from that of other government public relations offices by emphasizing, "Here we do not do spin." If the court is more accommodating to the press than it was in days before syllabi at the start of slip opinions and a public information office, the Supreme Court press corps still lacks the inside information that is grist for reporters' mills in other places. Because confidentiality is vital to the way the third branch works, that lack of information is likely to persist as long as the court exists. One prominent press representative just this week wrote to me, and I quote from his letter, "For years, news organizations have asked the court for a lockup, similar to those conducted by other government agencies. Reporters would report to a room at a designated time before 10 a.m. on decision day and would receive copies of that day's opinions. They would not be allowed to report on those cases until each was announced from the bench. Not all reporters would have to participate, but those of us on the most pressing deadlines would have the opportunity for a more studied approach to reporting the court's work. For reasons I've never quite understood," the letter writer concluded, "the court has refused all such requests. I understand those requests and the pressure that generates them, but I do not anticipate any change in the court's response and can only repeat what I now know from experience. Confidentiality really matters in our workplace." Legend has it that justices, even chief justices, once took phone calls from some members of the press on decision days to explain nuances of complex cases, not for quotation, of course, merely to clarify potential ambiguities. That kind of conversation, I can say with confidence, is destined to remain legendary. Endeavoring to divine what is going on behind the scenes, the Supreme Court press corps may feel a certain kinship to old-time Kremlin watches. Kremlin watches once made projections from the identity and position of party leaders atop Lenin's tomb at the May Day parade. Similarly, the press sometimes gleans from small or ambiguous clues or cues, sometimes accurately and sometimes not, indications of shifts or trends. Despite the lack of access to inside information, the press surely has grown in its capacity to relate what the court does. No justice today need send the kind of letter Justice Stone dispatched on Erie. And I doubt any of my colleagues would say, as Justice Miller did late in the 19th century, the members of the press have combined to bring the courts and the administration of justice under their control by their appeals to popular prejudice, accompanied by the usual amount of lying. There are occasional slips, of course. Still too often, in my view, the press overstates the significance of an order denying review. Headlines, particularly, may be as misleading as they are eye-catching. For example, when we decline to review a decision from the Illinois Supreme Court in the case that has come to be known as the Baby Richard case, one headline read, "Controversial Illinois adoption rule upheld. Without comment, Supreme Court affirms biological father's right to baby Richard." And when we declined to hear a constitutional challenge to a curfew for minors in Dallas, Texas, a headline reported, "High Court appears to uphold curfews." My colleague, Justice Stevens, time and again, reminds that a denial of certiorari leaves the lower court decision unreviewed, neither approved nor disapproved. Reasons why a petition fails to attract the 4 votes needed to grant certiorari vary from the technical to the prudential. Review may be sought too late, the judgment of the lower court may not be final, a case may raise an important question, but the record may be cloudy, the lawyering may be poor, the matter may benefit from further study, further percolation in the lower courts. For in Justice Frankfurter's words, wise adjudication has its own time for ripening. Lately, I have noticed several press reports that are admirably clear in conveying what a denial of certiorari means and does not mean, and those efforts are to be applauded. The press tells the public not only what we decide and what we decline to decide, it also features oral arguments. The American Bar Association's Division of Public Education, in cooperation with the Association for American Law Schools and the Newspaper Association of America Foundation, is making a vital contribution in that regard. In advance of each of the term's 7 two-week sittings, the Division for Public Education publishes Preview, a journal containing a synopsis 3 or 4 pages in length for each case calendared for argument. Law teachers write the previews in commendably plain English. If Preview arrives on time, and it has this term, I may use it as a guide in my own preparation to determine how many hours I should reserve for reading the briefs and other materials, or to judge whether I will be aided by a law clerk's bench memo, or whether research of a particular kind would be useful. Now and then, the press ventures a tentative forecast based on oral argument. Last term, for example, we heard argument on April 20th in Honda Motor Company against Oberg, which concerned court control of punitive damages awarded by juries. 5 days later, the Legal Times described the argument for Honda as disappointing, a performance faltering and unfocused. The same report spoke of the performance of counsel for the punitive damage awardee, the personal injury plaintiff, spoke of that argument as dazzling, captivating the court. But in the fullness of time, judgment was rendered 7-2 for Honda, the party whose lawyer, in the first impression of the Legal Times reporter, had faltered and never recovered. I wrote a dissent in the Honda case. I was joined only by the Chief Justice, and as I recall, upon release of the decision, there was scant comment on the outcome or on the court's lopsided lineup. What should be the objective of press accounts of our oral arguments? Well, one television reporter offered this neat description. I hope, with an argument story, that you and your spouse will get into a discussion of which side is right. A worthy aim, don't you agree? Justices read aloud in the courtroom 1 or 2 page bench statements, but they do not hold press conferences when decisions are announced. Reporters must cope as best they can with our more than occasionally dense or technical language. Sometimes they seek enlightenment from the academy, sometimes from advocacy groups, sometimes from the humans most immediately affected. Opinions that open with an almost press release style summary can assist reporters to get it right. I have it on reliable authority that what reporters would like most, in many of our opinions, is a practical effects section in which we spell out the real-world implications of our decisions. But they know that that is wishful thinking, for case law generally does not work that way. We do not spell out practical effects, for we ourselves may see them only through a glass darkly. In our system of adjudication, matters seldom can be settled on the basis of 1 or 2 cases. They generally require a closer working out, often involving responses by or a continuing dialogue with other branches of government, the states, or the private sector. I turn now from reporting court decisions to feedback on court dispositions. As Judge James Oakes of the Second Circuit altogether accurately observed, life tenure does not mean insulation from inspection. Hardly an institution, Judge Oakes said, operates with so many built-in checks and balances capable of instant criticism. Judge Oakes mentioned among the critics one's own colleagues and other judges, law professors, law reviews, and to an ever greater and more professional extent, the press. To that list, I would add Congress, and will comment first on the legislature as an audience for and a responder to judicial opinions. Most of the work currently done by federal courts, including the Supreme Court, involves not grand constitutional principles, but the interpretation and application of laws passed by Congress, laws that are sometimes ambiguous or obscure. When Congress is not clear, courts often invite and are glad to receive legislative correction. The law Congress declares, as the Chief Justice recently stated, is by and large the law federal courts apply. When Congress has been Delphic or dense or simply imprecise, legislative clarification can ward off further confusion. Turning from the first branch back to the third, For much of the Supreme Court's history, indeed until Chief Justice Melville Fuller's 1888 to 1910 tenure, the justices generally did not circulate their draft opinions among their colleagues. The opinion author could compose and publish his opinion untouched by other minds. Today, we are more collegial. As I have elsewhere explained, when I circulate a draft opinion of the court, I receive in response Dear Ruth letters. They not uncommonly read, would you consider adding, dropping, revising to say? Or more hopefully, I will join if you take out, put in, alter, or adjust as follows. And there is nothing, absolutely nothing, better than a good dissent to force one to sharpen her presentation for the court. On a collegial court, in short, one's own colleagues are both dress rehearsal and opening night critics. Supreme Court justices benefit too from the efforts of other judges, both federal and state, to parse our precedents, revealing gaps we can fill or infirmities we can remedy the next time around. For enlightenment on decisions past, present, and future, do judges read legal commentaries and law reviews? Most certainly we do. Stanley Fuld, longtime judge and once chief judge of New York State, years ago reported a Benjamin Cardozo comment, any morning's mail may bring in a law review from Harvard, Yale, Columbia, or a score of other places to disturb our self-conceit and show with pitiless and relentless certainty how we have wandered from the path. The reviewer seems to say, as does a character in Shakespeare's Othello, it is a judgment maimed and most imperfect. New York's current Chief Judge, Judith Kaye, more recently and cheerfully said, parties do not necessarily have in mind the sensible incremental development of the law. Academic writers therefore become genuine partners in the court's search for wisdom. If law journal citations in Supreme Court opinions are less numerous than they once were, it may be because some in the Academy are writing on topics or in a language ordinary judges and lawyers do not comprehend. But articles accessible and useful to judges remain in vogue. Last term, for example, a Yale Law Journal article sensibly discussing plain meaning and hard cases received credit lines in 3 Supreme Court opinions, 2 of them mine. Judge Learned Hand long ago said what I believe remains true today of law teacher and judge. Each is necessary to the other. Each must understand, respect, and regard the other, or both will fail. Returning finally to the press, Justice Frankfurter, it is said, urged the press to cover the Supreme Court at least as well as it covered the World Series. In 1994, for once, his counsel was heeded. But even if that never happens again, the press can be relied upon to assure that the court will not, as it should not, exist, to quote Frankfurter again, as a mystical entity set apart from the community and spared the criticism for which, in a democracy, other public servants are exposed. There is each term some murky decision reporting, a veteran Supreme Court reporter acknowledged, but he explained, murky decision reporting may accurately capture a murky decision. And I must say, so it may be. Critics of court products sometimes exaggerate to augment their point. Legislators may condemn a judicial opinion as sacrilegious, and I am not making that up. A dissenter may call a court opinion ludicrous, inexplicable, folly. A law review writer may overlook what does not fit into the writer's analysis. A defendant in a murder case who struck, bound, and blindfolded the victim, stuffed her into a sleeping bag, and carried her off to the place where she was shot dead by his sister, may be described in a newspaper account as anticipating no harm to another human. It is indeed hard, under the pressure of publication deadlines, to describe judicial opinions with entire accuracy, and to describe judicial decisions accurately, one of my colleagues has observed, is in many cases to describe them boringly. To sum up what I have tried to convey, participants in the U.S. system of justice prize fair comment on the work judges do. To assure ample room for such comment, members of the judiciary must expect and abide even comment of the unfair, uncomprehending kind. May I thank this audience for receiving these remarks in a manner most fair and comprehending. You take the people because I don't want to. Not to detain you from the refreshments, we'll take just a few questions, and the good dean will make the choice for me.
Well, I'll be a good academic and invite our students to offer these questions. And while they're thinking of that first question or two, I just wanted to comment on a wonderful historic linkage. The Justice quoted to us some very blunt language from Justice Miller. And I wanted to add that when this law center began offering classes in 1870, Justice Miller, who'd been appointed to the Supreme Court by Abraham Lincoln, was on that very first faculty. So I thought it was a wonderful bit of historic linkage. All right, is there a question for the Justice? Yes, right back here.
Getting back to President O'Donovan's comments about public service in the law school and looking at the way tuitions have risen in the 1980s, could you comment